Good afternoon, everyone, and thank you for joining us for the Medical Board of California Interested Parties meeting. Pursuant to SB 189, this meeting is being conducted via WebEx. Public comments will be heard for individuals wishing to do so. In order to be ready for public comment, we ask that you please ensure your comments can be heard clearly by connecting to the audio of this meeting through the proper method. If you're having difficulty hearing the audio of this meeting, it could be because the device you are connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application and then select Switch Audio. You'll see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you're having audio problems with your device, this will still allow you to participate and hear the audio of the meeting. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. Thank you, Bill. You can now start the meeting.
Thank you very much, Sean. I wish everyone a good afternoon and welcome to our interested parties meeting. The purpose of the meeting is to seek public input on the board's legislative proposals and priority during the board's sunset review, which will be taking place next year. And so we ask that you please limit your remarks to these topics. Please do not discuss any pending complaints, pending license applications, or pending disciplinary actions that may become the board for decision. Today's meeting is being recorded and will be provided to the board members. The board's legislative proposals and priorities are expected to be finalized during their upcoming meeting on the 1st and 2nd of December. These priorities have been circulated and have been around for a long time. And I'd just like to highlight some of the board's legislative priorities, which will be going forward in sunset. Of course, there is the need for the fee increase, which is very well rehearsed and goes back a number of years. The board is also proposing a change in the evidentiary standard from clear and convincing evidence to preponderance of evidence, which would simply align our standard, our evidentiary standard, with the very significant majority of other national medical boards. We propose that there be a lay majority of members of the board. And also we have several proposals to streamline enforcement, including enhanced enforcement of subpoenas and better access to medical records. During the meeting today, no dialogue is planned, but rather this is an opportunity for the board to listen and to receive additional input. We welcome inputs on our specific legislative proposals. We particularly welcome input from members in the public on how they would like to see us prioritize our legislative proposals. And then, of course, we're very anxious to hear your own proposals, which may be completely unrelated to anything that the board or the staff have been asking for. Written comments are also being accepted, and you can send them to sunset@mbc.ca.gov. Each participant will have up to 3 minutes to comment, and we look to conclude this meeting no later than 4 p.m. This afternoon. Sean, may you please begin?
Yes, thanks, Bill. The Q&A window and the hand-raising feature have been activated in the WebEx. If you'd like to make a public comment, you can simply hit the raise hand feature or type anything into that Q&A box, and that will let me know that you're willing to make a public comment. At the time I call your name, you'll be set to prompt to unmute the microphone from your end, and your time will start once we get your line opened up there. I'll give everybody a verbal cue when 30 seconds remain, and then ask you to please conclude when you reach your 3-minute limit. And then for call-in users who have called in only by phone, I see a couple here, you can raise your hand by pressing *3. Careful that *3 toggles raising and lowering your hand there, so you should hear a prompt from the WebEx system when you raise your hand or lower it. And then at the time I call on you by your area code, you'll get a prompt also to unmute your microphone by pressing *6 on your end there. So let me go ahead here. The first request we have here is from Eric Andrews. Eric, I'm sending you that prompt to open your line.
Hello?
Yes, we can hear you.
Okay. Since the board wasn't asked to participate in this meeting, it sort of defeats the purpose of this interested parties meeting. If there's no dialogue, there's really no point in this since we can't be heard, since we can be heard about the very same things at the quarterly meeting and then it's on the official record. So I'm just going to leave this at one question for now. Do you think that BMP section 2330 inhibits patient safety? And if so, are you willing, as the board, to take action to remedy that? That's my one question for today, and I'm just going to leave the rest of it for the quarterly meetings because I think this meeting, again, is just going to be you guys blowing smoke up our asses. Thanks.
Thank you for your public comment. Next here we have Susan Lauren. Susan, you should be receiving that request on your end.
Hi, good morning. Good afternoon, actually. I support your fee increase, change in evidentiary standard to preponderance of evidence. I see a problem with access to medical records because we're still not getting to the core of it, which is that the records come and they're lies and they're fakes, and we really need to have consumers co-authoring the records, and I'd really like to see you going to the core of that. Also, as far as not on your list, and you know what I'm going to talk about, California needs to focus on preventing medical harm. We all should know by now that is part of an endocrine organ related to sex hormone production, metabolism, insulin interactions, and the great list of health problems that are delayed and cause long-term. So removing this important part of this important organ is not in the best interest of the consumer's health. In California Business and Professions Code 2259.7 says the medical board shall take into account the most current clinical and scientific information available regarding liposuction. And since there's plenty of scientific information out there, you know, saying, among other things, you take a cell from here and it comes back to there and it comes back as visceral fat causing all these problems, you're not paying attention to this information. I don't know why. I mean, other than money or greed, or it just doesn't make sense. People are harmed. I'm not the only one. I just happen to be the only one that calls all the time. Believe me, I've got cheerleaders behind me going, say this, and they're like, I can't call. I'm in the middle of trying to get a lawyer. I'm devastated. I can't speak to anyone about this. And there's multi thousands of people harmed. This is what it is. So California changed their law, and I ask for, Florida. And Florida, by the way, they have a mandatory state regulation. I've sent it to you in the notes, and I've talked to Carrie Webb and Reggie about this. And I asked for starters that California meet Florida's regulations. I'd like you to move on this year, because every year that this goes by, or for another few years till the next sunset review, more and more people are being harmed. And I'm worse all the time, I can tell you. Okay, so I ask that you amend the code, remove mention of aspirate by volume, instead require profiting physician to prove the proposed treatment is medically necessary, beneficial in short and long term, and risk-benefit positive, because it's not. None of it is. It's just a pinch and guess. And they don't have any differentiation between me, someone who is 5'2", extremely athletic and fit, and like a 6'5" obese man. It's ridiculous. So also, you know, it's not for the meeting, you need to talk about getting rid of the experts like Carrie Dubrow, who, you know, have been sanctioned by the Military Health Agency and have lied in other places. It's not a good board when you have that kind of.
Thank you for your public comment. Next up, we have a caller from the 951 area code. Caller, you should be receiving a prompt on your end to press *6 to unmute.
Good afternoon. My name is Monty Goddard, and thank you for this opportunity for the public comment. I'm a resident and a licensed civil engineer in California. I speak for my wife, who suffers loss of life function due to undertreated pain. I have a specific request of this task force for which I must provide some background. I actively participated in the board's ongoing update of the 2014 opioid prescribing guidelines at the July Interested Parties meeting and the full board's August quarterly meeting. Board members at both of those meetings voiced concerns when they recognized publishing of the updated opioid prescribing guideline alone would not remedy. These concerns related to the very real fear of physicians in prescribing opioids and pharmacists in filling opioid prescriptions. Another concern related to getting insurance companies out of practicing medicine. California Senate Majority Leader Mike McGuire and his staff has met with several pain patient advocates seeking legislative relief for California's innocent, vulnerable, unjustly suffering pain patients. While supportive, he has yet to introduce such legislation, citing COVID-related backlog in the legislature. According to his staff, this backlog may be easing. On October 25th, I requested Senator McGuire propose legislation to amend California's Health and Safety Code, Pain Patients' Bill of Rights, by simply adding 2 sentences from this past August enacted Minnesota law. These 2 sentences explicitly protect physicians and pharmacists prescribing and filling opioid medications for the legitimate treatment of pain and prohibit insurance companies from refusing to cover related charges. Recognizing the fortuitous timing of the board's updating of its opioid prescribing guidelines and its legislative proposals and priorities, coincident with my similar request of Senator McGuire, I'm requesting this task force recommend the board officially encourage Senator McGuire sponsor the addition of the 2 sentences from Minnesota law, pain patient relief law, to California's Pain Patient Bill of Rights. I submitted written comment on Monday to the website cited earlier, which I hope you have or will read. It provides detail, including edited and unedited versions of the 2 Minnesota law sentences I propose be added to the California's Pain Patient Bill of Rights. Thank you for your time. Much appreciated.
Thank you for your bill comment. Next up here, we have Black Patients Matter. You should be receiving that prompt on your end. Like your line is open.
This is Dr. Ree with Black Patients Matter. I thank you. I thank the medical board for giving us this opportunity to speak again. And so previously we had brought up the idea of mediation. And at the last meeting, it was great to see that at least 3 medical board members openly stated that they're embracing the idea. And so certainly we offer the solution of mediation, and there have been a lot of complaints coming from the advocates, from the patients. Physicians' fees are going up. Employees with the medical board are upset about the amount of work. And so we at Black Patients Matter originated the idea of mediation. Mediation will be the solution. It will be forthcoming in the next year or 2, but likely we will be awaiting for a new chairperson with the medical board. Our current chairperson, Ms. Lawson, does not have the skill set to take us to the next level, that being mediation. So we will await for the next leadership in the medical board. So with mediation, the patients will have the choice, the option, the opportunity to sit down with a neutral party and also with the physician, and between themselves have some type of arrangement or discussion or some type of closure. And so the details of which we are working with legislators in drafting a resolution. And so I've also reached out to the FSMB. And so we will be at the FSMB meeting in May. We will have a presence there. And we had also reached out to the Medical Society of New York as well as other medical boards across the country, because mediation is the solution. It is a good
30 seconds remaining.
option. So thank you again for this opportunity to voice our idea. Thank you.
Thank you for your public comment. And for anyone who joined the meeting late, the hand raising features and the Q&A box are open in WebEx. You can go ahead and type a message in the Q&A box just indicating you'd like to make a public comment. I can call you that way, or you can raise your hand. If you're on a call-in line only, you can press *3 to toggle raising your hand that way as well. Next request here we have is from Christina Hildebrand. Christina, you should be receiving that prompt on your end.
Christina Hildebrand, can you hear me?
We can. Please go ahead.
Hi there, Christina Hildebrand from A Voice for Choice Advocacy. We educate and advocate for informed choice and transparency of what goes into your body. I have to say I'm a little disappointed about this too. This is not what I was expecting, but I guess it is what I was expecting given it's the medical board. So I thought the medical board was going to present sort of legislation, and you did to some extent, but you really didn't present any legislation that you're really looking at. My understanding from what Mr. Persifka said was that you are going to try to bring back SB 920, which was the ability to get medical records without a subpoena if the patient or the doctor does not wish to give them. We are strongly opposed to that. We were strongly opposed to it when it was introduced by Senator Hurtado this year. I think you will find it hard to get that legislation passed. If you look at the opposition on that, the ACLU was opposed, the CMA was opposed. All the people that you usually are in line with were opposed. Many physicians groups were opposed to it, and many consumer groups. So I would ask the board not to waste their time on that. I understand exactly why you want to do it. It has to do with medical exemptions, vaccine medical exemptions, often when patients are not involved in the complaint. And you want to get those records, even though the patients are completely happy with their doctor and how their doctor has performed. I do ask you, and this was brought up by me and many others in the last meeting, but you didn't mention it, so I'm guessing the board is ignoring us, that you involve patients in the complaint process and that the patients get a say and get their voice heard during the hearing process, and really get the patient and become patient focused rather than just being the medical board up against the doctor. I think, there are many things that the medical board needs to sort of do to make it a better board, to make it a consumer focused board. But those are the two key points that I have to make. Thank you.
Thank you for your public comment. Next here we have Ann Fuqua. Ann, you should be receiving that prompt on your end. There you go, Ann. Looks like your line's opening.
Are you able to hear me?
We can. Please
Okay,
go ahead.
hang on. Okay.
And can you please be
right.
muted? I need to start your time.
What's that? Can you hear me?
Please, yeah, please go ahead. I'll go ahead and reset your time. Thank you.
I'm Ann Fuqua from Families for Intractable Pain Relief, or Families for Intractable Pain Relief. First, let me say that I am so grateful for the time and effort the committee and board as a whole have devoted to revising these guidelines. Kristen Ogden and her husband are flying home today, so they can't be with us, but both Kristen and I would like to convey our sincere appreciation. I think the overall tone and message of the guidelines is reasonable for typical patient scenarios. My concern is that not all of us are fortunate enough to be typical patients. Outliers like fellow patient members of Families for Intractable Pain Relief and myself are human beings too. We have goals and dreams. I would give anything to be able to go to grad school, to do public health research, like I've been doing as it is with all the, patient harms for the past, 8 years, and no longer subsist on Social Security. Access to pain relief is an essential if I'm going to succeed in school. I had already started up grad school. I second Monty Goddard's request regarding additional protections similar to those passed in Minnesota. I recognize this was an action taken by the federal government, not the board, but I believe boards must stand strong and show the DEA they support pain relief for all patients, even those who require higher doses of opioids like me. My last increase was in 2008, and I have had an excellent quality of life for the past 14 years, despite being on a dose that far exceeds the CDC guidelines. As I sit here today, my life has changed radically over the past week. On November 1st, my physician's DEA registration was suspended. The DEA made no arrangements for patients. A methadone clinic is treating my withdrawal, but my previously well-controlled pain from dystonia and arachniditis is now intolerable. Beyond that, the dystonia makes it almost impossible for me to function independently. I was so grateful to live independently. I had worked for years to be able to stand and walk short distances holding onto a counter. I am barely able to fend for myself right now. My quality of life has been decimated. I'm praying that this will improve somewhat, but this has not occurred during past attempts to taper or in 2015 when my previous doctor retired. As it stands now, I want to live more than anything, but right now I'm only existing in severe pain
30 seconds.
needlessly. I have a few amazing friends helping me right now, but without improvement, I would likely be forced into skilled nursing 1 to 2 years for Medicare waiver care. I'm 42 years old. The thing I'm most grateful for is my independence, and I can't give that up. Without a new miracle treatment or a physician willing to restore the regimen that has a proven track record for me as an individual, I will have to make the same difficult decisions many patients have made before me. I want to live more than anything, but this is not living right now, and I'm not going to exist like this.
Thank you for your public comment. Next up here we have Marion Hollingsworth. Marion, you should be seeing that prompt on your end.
Okay, can you hear me?
We can, Marion. Please go ahead.
Okay, thank you so much. First, I'm disappointed that there's such a poor show of the board on this meeting. I was expecting more participation. But as to my requests, the Medical Board of California is in dire need of changes to make it truly able to fulfill the goals of its mission statement, which is to protect healthcare consumers. Please submit my suggestions to the Sunset Review Committee for consideration. First, doctor licensing fees need to be raised to $11.50 every 2 years to ensure the board has enough funding to investigate and prosecute doctors who harm California consumers. That's only $1.57 per day. Second, the legislature needs to pass a bill to change the board's disciplinary guidelines into mandatory disciplines. Currently, the board doesn't even follow the minimum discipline, often allowing dangerous doctors who have even killed patients to get away with as little as a reprimand. Third, Business and Professions Code 2330 requires consumers to surrender any control or authority over a doctor complaint. Doctors have the right to counter the complainant's claims, but under 2330, the complainants have no right to hear what the doctor's claims are. Consumers aren't kept updated on the status of their complaints and only hear of an outcome after a disciplinary decision is reached. Doctors can appeal a decision, but consumers cannot. An overhaul of 2330 will ensure consumer rights. Number 4, the issue of chaperones for doctors on probation for sexual misconduct needs to be addressed. Currently, there are no laws dictating who is qualified to be a chaperone. It can be an employee who can be pressured into lying for a spouse, also close friends, into lying for the doctor, rather. Even close friends or spouses can be considered chaperones, which can also lie to keep offending doctors in practice. Fifth, the medical board should be required to be mandatory reporters for cases of physical or sexual abuse. Law enforcement should be notified when these complaints are received. This way, the doctor would be investigated immediately and either cleared or prosecuted to ensure public safety. Finally, consumers should be told if their doctor is under investigation, especially since it takes the board 3 years to complete a full case on average. The CSLB posts notices of contractors who are under investigation, so the board should be able to notify consumers of doctors being investigated as well, particularly for egregious misconduct or death cases.
30
Healthcare
seconds, Mike.
consumers need to know the license status of their doctors so they can be fully informed and therefore be able to make appropriate decisions for their own care. Thank you for your time. Please submit my suggestions to the Sunset Review Committee. Thank you.
Thank you for your public comment. So next here we have Michelle Montserrat Ramos. Michelle, let me send you that request. Should be receiving that on your end. There we go. Michelle, are you there?
Yes. Good afternoon. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. We are requesting that the complainants be interviewed following the physician interview. The request is that seriously bodily injury and death cases cannot be closed without a complainant interview. This is not a new issue for the board. It is a recommendation that has been brought forward and discussed since 2017. It was a Sunset BMP recommendation back in 2017 to ensure that patients have an opportunity to provide information that may be critical in determining what steps to take and whether they are ever proactively informed when a complaint leads to formal disciplinary action. It was included in the 2018 Patient Bill of Rights presented to the board by Consumer Watchdog and patient advocates. Again, it was a 2021 Sunset Review BMP recommendation to ensure that patients have an opportunity to provide information that may be critical in determining what next steps to take and what efforts the medical board needs to take to ensure individuals who file complaints are proactively informed throughout the process. During the 2022 BMP oversight hearing, this board was grilled by Senator Roth on whether every complainant is interviewed before complaints are closed. Jenna Jones acknowledged that they are not. The public and the Sunset Oversight Committee has been requesting a complainant interview before a complaint is dismissed for 5 years now. This board has been discussing this public and legislative concern for just as long. It is now time to take action and make this recommendation one of your legislative priorities and include it as a sunset issue. We're also asking this board to move forward to adopt the Department of Consumer Affairs complaint prioritization and referral guidelines that other boards use, so all quality of care, death, and serious bodily injury complaints must go to investigation. This recommendation must also be one of your legislative priorities and included as a sunset issue as well. These are two different distinct requests. The board must follow the same complaint prioritization guidelines for death and serious bodily injury that other boards follow, and the board must ensure that complainants have an opportunity to provide additional information and investigative information that is needed before a complaint can be
30
dismissed
seconds,
at
Mike.
any point in the enforcement process. Thank you.
Thank you for your public comment. Next here we have Virginia. Virginia, should be receiving that prompt on your end. Virginia, looks like your line's open.
Hello?
We can hear you, Virginia. Please
Okay.
go ahead.
Thank you. I also agree it's really sad to see that there's only a handful of people that showed up to this. I'm not sure how people are going to know what we want because I don't think they will listen to this. So anyways, I agree with the previous callers. I'm also going to voice my concern again that you can go through all this and spend all the money and time doing this unless you handle the role of the CMA who override you every single time. You're wasting your time and money. Because everything you put forth, your licensees, the CMA, override you. So it's really concerning you go through all this and you never discuss the role of the CMA in overriding you and causing harm to patients. Second, I'm asking for you to ask for money for prevention, to make prevention your priority. In doing so, you can hire people, consultants, patient safety experts to help advise you and to do prevention. You can do education on prevention. You can set up policies and preventions, policy and procedures for prevention. Otherwise, we're going to go round and round in circles with the same thing, and people are being harmed. Patients end up disabled with PTSD, with no money due to CMA. California pays all the disability payments, and then doctors who might care or might not care could end up with PTSD, second victim syndrome, and also some die from suicide, some get burnt out. So if you focus on prevention, you might end a lot of this, save you guys money, and people will stop being harmed. As it wasn't until recently that prevention and patient safety was even required in medical school. I still don't know if it's required in all medical schools, but doctors don't know that. There's other states that do patient safety and prevention, but California does not have that as a CMA CME requirement. So please ask the legislature
30 seconds
for
remaining.
money for prevention and do trauma-informed care and do everything everybody else asks for and what you asked for on May 6th, because you took some of that stuff out and it was important stuff. I wish you would put that back in and address the CMA, or you can go round and round and round and round in circles for the next 50 years. Your licensees shouldn't be more powerful than the board that licensed them. You need to do something about that. This legislative hearing, do something about that. Or all this other stuff is
Please
just
conclude.
waste of time. I'm done, but please do something about that and stop wasting time with CMA.
Thank you for your public comment. Next request we have is from Rosie Arthur's daughter. Rosie, you should be receiving that prompt on your end. Rosie, look like your line's open. Are you there?
Yes, can you hear me?
We can. Please go ahead.
Okay, I'm sorry, I just joined the meeting because we had a power failure and then Windows had to reload. So it took more than a half an hour, so I'm sorry I'm late and I missed whatever the introduction was. I have been in communication with the board regarding the guidelines and the updating of the guidelines, and specifically looking at areas that were omitted because most of the guidelines were 20 or more years out of date. And I forwarded information regarding the increase in serotonin syndrome that has come about as a result of discontinuing opioid therapy and instituting other therapies, saying the person's now depressed, and not everybody can handle those medications, and it can actually kill a person. So you can take a person who is being treated appropriately with opioids, and in a matter of days even, or longer, facilitate their untimely death. Anyway, this is not new science. This has been around for a number of years, and it's been in other guidelines such as the VA and DOD. There are tests to help with deciding which medications, and it's not just pain medications, it's medications across the board, because you oftentimes have polypharmacy. It's something that has to be considered. And sometimes the opioid therapy is the safest therapy. So, and this has been ignored. So this is one of the things I've been promoting is providing the information, the guidelines, and I do understand that various groups haven't updated their guidelines, or they have taken certain parts of certain guidelines and applied them in a way that was not intended. And that's across the board with everybody. So when you're updating the guidelines, we really need to make sure that the guidelines are actually being updated. It doesn't do any good to update a 40-year-old guideline
30 seconds remain.
that doesn't include the medications that are now available and the testing that is now available. And to ignore that is ignoring science. Anyway, this is the big fault of the guidelines, is a lot of time is being wasted trying to update something 40 years old and not looking at what's currently available to help people. Thank you.
Thank you for your public comment. Next up here we have Tom. Tom, I'm sending you the request there to open your line. There you go, Tom. Looks like you got the line open. Are you there?
Yeah. Can you hear me?
We can, Tom. Please go ahead.
Okay, thank you. Dr. Stefan Kertész is a doctor of addiction medicine at the University of Alabama in Birmingham. In early 2019, he spearheaded efforts to get the CDC to acknowledge widespread misinterpretations of the 2016 guidelines and the harms being done to chronic pain patients. The CDC responded, agreeing and issuing public statements to that effect. Dr. Kertész has also been noticing since at least 2017, I think, that chronic pain patients' suicides were becoming alarmingly frequent as more and more were being involuntarily tapered or cut off entirely from their pain medications. He has led efforts to start a program to study this growing tragedy and recently received funding from the VA to move forward. He and anyone who cite pain patient suicides get angry pushback from anti-opioid advocates like Andrew Kaladi and Anna Lemke, who are from this group called Physicians for Responsible Opioid Prescribing, or PROP. And they both have outsized influence here in California. Another person who's pushed back is Adrian Pugh Berman from Georgetown University, who's with a group called Farmed Out. And they angrily contest that anyone would commit suicide merely from pain. In a video debate with Dr. Pugh Berman about pain patient suicides, Dr. Kertész asked some troubling questions. Regarding forced tapers, he asked, do we ordinarily take non-consensual actions on patients who are adherent and stable, absent strong evidence for those actions that sometimes result in a patient's deaths? Do we let others induce physicians to take such action? If we answer no, not usually, then we must ask if we have some justification so powerful as to overcome customary medical ethics. Regarding pain patient suicides, he asked, if this has raised a concern, ask this, might we be harming some very disabled people? How comfortable should we be with policies that leap ahead of data? If harm is happening, why would a public agency not be willing to investigate despite being asked directly? And finally, he asked, is there something about the lives of people who have received long-term opioids for pain that makes their lives or deaths not worth measuring and investigating? And I just want to mention that a woman who lived not far from me named Deborah Bales had gone out after her husband's insurance lapsed. She lost her coverage. She went to had this new philosophy, and she went out to the coast where I'd spent a lot of time as a kid, and she hung herself. I would also like to mention that Dr. Kertész is supporting this Minnesota law that has been mentioned before as being supported by Mike McGuire's office, and he thinks it could be an example for the country. Kate Nicholson also made some, the CDC guidelines, the revisions were just made, came out last week. And Kate Nicholson, who's executive director of the National Pain Advocacy
Please
Center,
conclude.
said, there are tweaks, but I think they are tweaks that are meaningful. That doesn't mean it's not still built on a rotten core. So just keep that in mind if you look at the.
Thank you for your public comment. At this time, Bill, I do not see any additional requests in queue. Sorry, Bill, your mic is still on mute.
Okay, Sean, can you hear me now?
We can, yes.
Okay, sorry for that. Thanks everybody for participating in today's meeting. Your input is invaluable. Additional written comments may be sent to sunset@mbc.ca.gov. Comments received will be forwarded to the board members. Again, want to thank everybody for participating. All your comments are welcome, and they will receive careful consideration. This meeting is now adjourned.